No. On Tuesday, the Counter-Strike Professional Players Association released a statement directed at Blast titled "Players Refuse Blast Access to Voice Comms and Video Screen Recordings Without Agreement on How Information is Handled." This sparked outrage throughout the CSGO community, including delaying matches that were already scheduled to be played between Na'Vi and Astralis, which actually made the match go farther into the night than anyone expected, going way past 2 a.m. Moscow time, and while Simple might be a god on the server, still needs to sleep. The letter complained, among other things, that players were now going to be required to record their voice communications where they had not been required to do so in the past. This is significant to players because they say that they have no idea how this information is going to be used or shared. Now, of course, many in the community were quick to point out that this is probably in direct response to the cheating and stream sniping allegations that have been plaguing the CSGO community the entire year. But the CSPPA says that regardless of what Blast's intentions are, the measures that they've implemented are both harmful and illegal if they do not have clear agreements with players on how to store and use information. And that was all we were going to talk about. Are Blast's actions illegal? But as the week went on, things got a little more interesting. But let's start with the legal analysis and see where that takes us. And that starts with one simple question. Can Blast use players' voice communications without their permission? Well, part of that depends on what type of law you're looking at. Now, without going too far into it, international contracts are almost always going to have a choice of law provision. And that choice of law provision is almost always going to be written by the person who wrote the original contract. In this case, it's probably Blast, since they're the ones who are always going to be a party to the contract, whereas all these other teams come from all over the place. Something that's probably already pretty apparent to you is that I am not a Danish lawyer, I'm a US-based lawyer, and so Danish law is pretty foreign to me. But US law, I know how to research, and so it's US law that we're going to be talking about. So with that in mind, make sure that as you're watching this video, you realize that Danish law can and probably does slightly differ from US law in a couple key points. But with that out of the way, let's talk about the basic rule. A person's likeness cannot be used for advertising without their consent. And in order to find an actionable invasion of privacy, we must first determine that the publication which the plaintiff finds objectionable constitutes a use of his likeness for advertising purposes or for purposes of trade within the meaning of the law. Now, courts in the US have interpreted what advertising purposes and purposes of the trade are pretty liberally over the years. In fact, they even found one time that a background actress in a movie that had no dialogue whatsoever had her likeness appropriated for advertising purposes. Now, whether you can actually establish if you lost anything in that particular instance is another story, but that's not actually where we're going with this. Going back to our issue, Blast has already said it's going to require players to use their voice communications if they're going to participate in current and future Blast events. So really, we're only left with one issue. What are they going to use it for? And if they're going to use it for advertising purposes, did they get the player's consent first? Now, obviously, if Blast intends to use these voice communications in their broadcasts and other materials used to publish and produce and do all whatever they're going to do in their tournaments, then sure, it counts as advertising purposes, and they're clearly going to need the player's consent to use them. But it's weird because the CSPPA doesn't actually seem to care about whether or not it's going to be used for advertising purposes. Instead, they seem to focus on this. Players have experienced that voice comms were shared with analysts and others, which has led to sensitive tactical information and personal information being shared among people in the community. Information which was never meant to be shared and should never have been shared with analysts and others in the first place. Clearly, if this is true, it's terrible. Teams and players spend a whole lot of time perfecting their strategies, keeping their strategies secret, and making sure that they are theirs and no one else gets a hold of it. And so that should never be shared with anybody unless the players and the teams give it themselves. But let's not forget that just giving that information to analysts doesn't violate the basic rule that a person's likeness can't be used for advertising purposes without their consent. The problem arises really whenever analysts try to use that information in their broadcast. Let's say, for example, that Na'Vi always stacks 3 people on bomb site B whenever Astralis is on an eco. And analysts know that because they have listened to these voice comms and they found out that every time that Astralis is on an eco, they always rush B. And so they tell their viewers that in this upcoming eco, you can probably expect that Na'Vi's going to stack 3 on bomb site B and then Astralis is going to rush it. In those instances, it'd be kind of difficult to say that those players' voice comms hadn't been used for advertising or trade purposes. But as we mentioned before, Blast probably isn't going to use those voice communications for that purpose. You see, 2020 CSGO has been rife with cheating, stream sniping, bug exploits, what have you. And there's been a lot of pressure from the fans for tournament organizers to get a handle on that, especially in this COVID world where everything is done online. And for that reason, Blast would probably point to these recordings and say that they're only going to use them for the purposes of stopping cheating, because if they have your voice communications, it's a lot more difficult to cheat. And while normally the rule is that no cause is so exalted that it may allure by exposing the portrait of a person to the public gaze. In other words, good intentions don't get you around the law. But that doesn't even really matter if Blast is only going to use those voice communications to stop cheating and not for advertising purposes. Now, I reached out to the CSPPA and to Blast for comment on this issue, but in probably the least surprising turn of events that has ever occurred in history, I have not heard back. So we don't really know what it's going to be used for. We can make assumptions, but without the original contracts, and I don't think those are out there anywhere, we can only make assumptions. So since we're making assumptions, let's go ahead and assume that Blast is going to use these voice communications for advertising purposes. And that's not just because I want to finish the law part of the analysis, but also this is where the story actually got a little bit more interesting. On Wednesday, Navi posted this tweet: "Dear Counter-Strike community, the teams and all tournament organizers, including Blast, have worked, are working, and will continue to work together to ensure that any and all of our players' needs pertaining to their participation are met to the extent possible. As a result of this already successful partnership between the parties, Blast resolved the issues raised around the usage of voice comms already on November 23rd. We fail to understand how and why the CSPPA are involved in trying to raise concerns with an already resolved issue without our knowledge or any form of previous communication." Now, while the teams are not the players, and many in the community were quick to point that out, it does give me a chance to teach you a little bit about agency law. Now, oftentimes players don't negotiate for themselves, and it's for a pretty good reason. Lawyers, agents, people who do this for a living and do it all the time are much more likely to come to a reasonable agreement that benefits all the parties better than a player or some other party would do themselves. Now, in those cases, players use agents, and in those instances, there's also a general rule. An agent can bind the principal if they have the express or implied authority to do so. Express authority would be like if a player went to Navi and they said, "Hey, Navi, you have permission to go sign contracts for me and give people permission to use my likeness however they want to." But no. And so we go to implied authority, which is much less direct because it's implied. Implied authority goes a little bit like this. A player signs with G2, they give G2 permission to enter into contracts for them to enter and play into tournaments, to use their likeness to promote the brand, and all the little stuff in between. That little stuff in between is the implied authority, and it's based a lot off of what is general practice in the field and the interactions that they had with G2. Now, G2 would take that implied authority and they would do all the details that comes with signing those contracts and getting players into those tournaments and all that stuff. Like signing a November 23rd agreement that gave Blast permission to use the voice communications, for example. So what does that mean for the purposes of this video? Well, likely it means that Blast is completely in the right to use the voice communications as long as they're within the confines of the consent given in the November 23rd agreement. But it also means that the CSPPA is probably way off base in saying that what Blast is doing is illegal and harmful. Because even if Blast intends to use those communications for advertising purposes, if the orgs negotiated that in the November 23rd deal, then it probably cuts off any illegality or tortious behavior on the part of Blast that's being alleged by the CSPPA. But just to cover all my bases here, even if these organizations didn't have the express or implied ability to enter into the contract on behalf of the players have been playing matches since 23rd and recording their voice communication since November 23rd up through to this December 8th letter and then now past it. And so because of that, they've probably ratified the actions of their agents and are therefore probably bound by that November 23rd agreement. So where does that leave us? It leaves us where we started. Yes, Blast can use those voice communications as long as it's within the confines of the consent given in the November 23rd agreement. No, Blast are not stealing players' voice communications without their permission. But that leads us to other questions like, where does it leave the CSPPA? Where does it leave the players? What if they don't want to be bound by the November 23rd agreement and want to negotiate other deals? That's a topic for another video. As for now, I want to thank you all for watching, and for the first time, I'm Attorney Muffin. I'm an attorney, I'm not your attorney. You should always seek out better legal advice, and I'll see you next time.